Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about a company that does, among other things, create infant formula. Baby formula, shake it around, feed it to kids. And this is a company that is owned 51% by our plaintiff today and 49% by one of our defendants today. And that 49% minority shareholder is controlled by two natural persons, and those natural persons, real flesh and blood, not companies, they are the former CEO and former directors of our infant formula company itself. And what our plaintiffs today say is that as part of in their role as sort of directors and people controlling and dealing with the infant formula company, that our natural person defendants today breached some of their duties to the company itself. And so what our plaintiff wants to do today, in its role as a shareholder, is to seek leave to bring a derivative action on behalf of the baby formula company. Right? Let me just refresh your memory on why an application of this kind might be made. Now, if you're the shareholder of a company, you merely own shares in it. You're not the director of the company. You're not controlling what it does. And that means that you might be sitting there owning shares in an entity and be frustrated with something that's happening, or be frustrated, for example, that a company is not pursuing a claim. And so you might come to the court to seek to bring a derivative suit to seek leave to sort of stand in the shoes of that company and bring the claim that you say the company should be bringing but is not. So that's what's happening today. So our plaintiff says, I want leave to stand in the shoes of the baby formula company in order to go and sue these defendants, sue these directors for the breaches of duty. Now, what the plaintiffs say these breaches are, there are sort of two broad categories of breach. Category one is that the plaintiff says the defendants have sort of caused this exciting opportunity for the baby formula company to be diverted away, and essentially that opportunity was to become the promoter and distributor of a certain kind of baby formula. And what the defendants did, in the plaintiff's eyes, was they caused this exciting opportunity to be diverted away over to some other entities that were created by the defendants or related to the defendants, or indeed related to members of the defendants' families. So they're saying you had duties to the company, and by diverting this opportunity away to your mates, you have breached your duties. Now, the other category is that what the plaintiffs say is that the defendants caused our infant formula, our baby formula company, to transfer ownership of certain trademarks out of the hands of the infant formula company and into the hands of some of the entities related to our two defendants today. These are the two sort of broad claims that the plaintiffs want to seek leave to bring on behalf of the company. So that's the application we're dealing with today. Now that takes us to section 237 of the Corporations Act, and there are 5 criteria there in subsection 2, and so the court has to work through them, and if each of those criteria is satisfied, the court must grant leave to a plaintiff coming in that sort of position. So let's work through the 5, and why don't we start off with number 1, which is the plaintiffs are able to comfortably prove that the company is not going to bring this claim. So that criterion is satisfied. The plaintiffs are able to comfortably prove they're coming in good faith, and the way a shareholder can do that in derivative suits is reasonably straightforward. Essentially, you're coming in good faith if you say, hey, I own some shares, I think the company's value will increase, and so the value of my shares will increase if I get to bring this claim. So there's no rule that says it's got to be holding hands, dancing around the maypole in order for it to be good faith. It just merely has to be often a genuine commercial interest in prosecuting what you consider to be a genuine and legitimate claim. So criterion 1, that's done. Criterion 2, that's done, we just did. Let's skip to criterion 4. The plaintiffs were able to prove there was a serious question to be tried, and that's one of the 5 criteria. And criterion 5, they were able to prove there was notice. That just leaves us with the rude finger criterion. Is it in the best interests of the company for the court to grant leave to the plaintiffs? Now, the rude finger criterion, that's a technical term, of course, is about best interests, and the way the plaintiff tries to satisfy that is to say, hey, I'll offer an indemnity in respect of any costs orders that the company, the baby formula company, might face if the legal proceedings are brought. What the defendants say is that offer of an indemnity ought to be broader and bigger than what you've actually offered, and so resists the idea that the normal size indemnity, if I can put it that way, provided by the plaintiffs is adequate. The court works through this indemnity question and says, well, in considering the rude finger criterion of is this in the best interests of the company, certainly it will only be in the best interests of the company if the plaintiffs provide an indemnity for the company in respect of adverse costs in respect of the litigation, but it doesn't necessarily need to go further than that, except for one additional element, that is one of the defendants is domiciled, one or some of the defendants are domiciled in China. And there is obvious complexity about enforcing a judgment in China, a lack of clarity about the costs that will arise from that. And there's expert evidence before the court, in fact, that no judgment of any Australian court has ever been enforced by a Chinese court. And so there's this challenging and open question of like, how is enforcement going to look even if the plaintiff baby formula company indeed ends up successful against defendant 1, defendant 2, and all these sort of knowing receipt defendants, all these related entities I referred to earlier, who knowingly took the benefit of the alleged breach from defendant 1 and defendant 2. So what the court says is, look, we've satisfied criteria 1, 2, 4, 5, and to satisfy the best interests criteria, you're going to need, the plaintiffs are going to need, to indemnify the baby formula company against the costs orders in this litigation, as well as the costs of enforcing any judgment in China. And so the plaintiffs leave with that conditional approval, and that is the position we're left with. Just a couple of little footnotes. There's a service question that is sort of kicked down the road for another day for the court to deal with, where there's some complexity where the plaintiffs haven't served one of the relevant entities they're trying to proceed against. And there is one other issue as well, that the plaintiffs bring a large number of claims, a large number of complaints, and in respect of some of them, they're unable to prove there's a serious question to be tried. So the court grants leave, says you've satisfied all 5 criteria in respect of a large amount of what you want to come and bring, but for some of this stuff, you haven't satisfied the court that there's a serious question to be tried. And so the plaintiff leaves with leave to go and bring the derivative suit. They succeed in their application. I hope that discussion assisted you, and I look forward to speaking another day in respect of another case and over another coffee. Cheers.